Okay, so this is a meeting of the Rutland Zoning Board of Appeals. Present are Chris Senecal, Vice Chair, Bob Paulson, Art Wells, Paul Corain, Jacob Morris, Tamika Murphy, Secretary, I'm Rick Surratt. First item on the agenda is a continued hearing application for appeal of building inspector's decision continued from January 12, 2022. Whitney Street Home Builders seeking appeal of building inspector's decision under the Fair Housing Act to build the same dwelling at 29 Barre Paxton Road that we heard last year. So at the meeting last month, it was my impression that Section 16 of 40A, which is a 2-year exclusion for applicants that bring the same matter back, applied. There was a discussion as to whether or not changing the legal theory. So instead of going under some vague, very vague legal theory concerning the Dover Amendment, which we really didn't even get into at last year's hearing. Instead of that, now we have a substantially identical application, only it's got Fair Housing Act stamp on it. So we can have a discussion on it, but I'll come out of the barrel saying that I think Section 16 applies. So what I'd like to do is I'd like to hear from the board members. We can start with you, Chris, and then we can have Attorney Para speak.
Section 16, so that's the one where they can't come back?
Yes,
and
if it's a substantially similar
if it is similar, if it's not substantially, if they're not coming back with a new plan, basically. I just want to understand the law and just...
Well, this is my interpretation of the law. If the plan and the relief is substantially the same, then they can't come back.
They can't come back, okay.
What they've done here is they've just changed the legal theory. And we can, and I know Art's going to speak to that.
In the legal theory, that's not...
Would it, yeah.
You're the lawyer, no, Artie,
would it make sense to have Art speak at this time?
I believe so.
Sure, yeah, go ahead.
All right.
Yeah, well, I think, Rick, you sort of summed it up anyway. I don't have that much to add. My understanding is that the relief requested is exactly the same as the earlier application that was denied and that's now up on appeal. So that application, in some fashion, it was denied at this level, but it's still pending as an appeal in Superior Court.
And it was the same application, correct? It was the the building inspector's denial.
Yeah, it was the same thing.
Different application.
No, different, but it was titled. It was the same title, like some are site plans, some are variances. It was whatever that.
They were looking for the same relief.
Well, there were 3 on the original one.
This is 2.
Yeah, there was
appeal
from the building inspector.
That's what it was.
Variance and special permit. We denied all 3.
We denied all 3, and this application was an appeal under the building inspector, the same thing as the first one.
Yeah.
Okay.
Well, my understanding, and this would be, maybe more for the non-lawyers, but essentially the requested relief, the variance, the first time around and the second time around is essentially for the same.
And the project is the same.
And I just wanted to clarify that the application type was the same.
Well, that's immaterial. You can call it an application, whatever you want.
So if you file for a site plan before, you could come back for a variance the second time or something.
Well, I'm just saying that, in substance,
yeah,
they came in the first time. The project was the project. The variance they were seeking was for certain relief. And as far as I can tell, now, on this particular application, the project hasn't changed. I understand maybe there's some more detailed plans, but it's the same project. It hasn't been changed in some material way. It hasn't been limited in size. They haven't moved the setback, or they haven't changed the square footage.
Yeah.
It's the same thing. And so in that circumstance, as far as I can tell, under the law that has come down under 16A, that's not a material change that is sufficient to avoid the 2-year moratorium, they call it. But in layman's terms, you can't come in twice for the same project looking for the same relief. And my understanding is that the legal theory of the second one is arguably somewhat different, but that doesn't meet what's required to make it a different application. And so that's all I'm saying. I've looked at some cases that's where I learned about this point. And again, I'm interested to hear from counsel for the applicant on his thoughts, and if he's got cases that would establish, that this application is sufficiently materially different to allow it to go forward. And that's a threshold issue. I mean, if that doesn't apply.
I would agree. I would agree. That material difference, I don't see anything different from the plans they submitted, the way they requested relief, anything different from what we reviewed last year to this one.
So
I'm totally agree with that.
From my point of view, we got the new submission from council today that has a variety of cases that all have to do with issues surrounding discrimination under the FHA. I don't think you reach that issue unless you can establish that you can come in on this particular second application on this threshold issue. I mean, if you can, then you move on to that argument. But the new submission from council actually doesn't mention 40A16. So for me, I would like to hear what council has to say as to why 40A16 doesn't apply in a manner to bar this application going forward, just on that threshold, sort of almost I guess I might call it a jurisdictional or sort of procedural issue. So that's what I'm saying about that. I don't know if anyone else wants to add anything to that, or other comments, or.
Okay.
I'm of the same position. This is the same exact project under a different legal theory. I think the petitioner needs to wait the 2-year period to bring a new application under the new legal theory that they're seeking to use now. I think that they're barred. The language is pretty clear, and I couldn't find anything that would say otherwise.
Would you like to be heard before or after Attorney
Actually, I'm not
Barre?
voting though, so.
That's right.
Yeah.
That's right. So
I
Paul.
would just say, I see no substance difference in the new application. The scope of the project has not changed, and there's no change in the material. It's the same project. It's a single-family home on a non-conforming lot.
Yes.
As an overview, as a rough thing, a single-family home on
Right.
a non-conforming lot. That project has not changed. It was previously denied. It's, it's 2 years, 16.
Yeah, so the plain language of section 16 is to prevent applicants from coming back again and again and again, and getting multiple bites at the apple. So, and there's also no reason why this legal theory dealing with the FHA couldn't have been included with the first application. All right, so Attorney Barre, would you like to be heard? Tamika, do we have Attorney Barre?
He's
Oh,
talking, but we can't hear you.
Yeah, it must be.
All right, Peter, is Peter?
There we go.
There you
Oh,
go.
there we go.
Can you hear me now?
Yes.
Yeah, good evening. Thank you very much. I don't really have a lot to add to what we said the last time around. The site plan, I think we acknowledge, is essentially the same as was submitted in the prior application. The difference here is that we're not seeking zoning relief. We're seeking relief under an entirely different statutory scheme. It's my understanding that you were going to review the issue with town council. I don't know if that happened or not. But I don't have anything to add to that. I don't believe 40A Section 16 applies to the Fair Housing Act. That's simple. So, with that said, if the board is of a mind not to reach the merits of the application of the Fair Housing Act, so be it.
Could I ask council a question?
Sure.
Do you have any cases that would support your argument that Section 16A doesn't apply because of the Fair Housing Act? In other words, it's preempted, or in some other fashion, 40A does not apply because of you're talking about the Fair Housing Act. I mean, do you have some cases on that point?
So, in specifics, no. And I don't believe there is a specific case addressing that issue. In generalities, yes. I mean, I think the whole tenor of the cases under the Fair Housing Act is that you need to set aside your zoning and permit qualified uses by means of what's generally termed under the Act a reasonable accommodation. And a reasonable accommodation is an accommodation that doesn't impose an undue financial burden on the town and doesn't, so subvert the zoning scheme as to essentially negate it in the neighborhood. And I think even, I don't think there's any basis for anyone to say that this causes an undue financial burden on the town, and the proposed development is well within the general single-family residential zoning scheme in the area. So if you ask me, is there a case that specifically addresses 48 Section 16 and the Fair Housing Act, I'm not aware of any. If you ask me, are there cases that, for want of a better word, require you to bend the applicable rules and grant a reasonable accommodation generally, then I would say yes, there are many cases, a number of which we cited in our original memorandum to the building inspector, and I believe that Mr. Benincasa provided you with some other case law today.
So is it your position then that the local zoning laws just don't apply across the board whenever the Federal Housing Act is being invoked? Because that's what I kind of understand you to be saying.
That's, I agree with you.
Well, no, to be fair, what I said is that the Fair Housing Act requires you to grant a reasonable accommodation, and I've given you the basic legal definition for the reasonable accommodation, which is an accommodation that doesn't impose an undue burden and doesn't, subvert your zoning scheme to such an extent as to negate it. So, no, I don't take the position that we get to throw out the zoning bylaw. I do take the position that you should grant a reasonable accommodation, and given the nature of this project, I believe it's reasonable within the zoning scheme because it doesn't impose any financial burden on the town. It's basically under your bylaw, the single family, residential use. I'm trying to think of, like a hypothetical where it would be unreasonable. And I think if you were to say, well, we want to insert a residential use in a, highly industrialized industrial zone, that might be an example of something that would not be reasonable.
Alex?
Yes.
I'd like to also, this is James Tatro, engineer for the applicant. I'd like to also note, supporting what Mr. Barre says, this proposed development would meet all of the setback requirements in this zone, would only alter just a little over half of the lot's area, and the frontage for this lot is sufficient that we are able to show two different driveway entrances, both having sight distance in excess of the minimum for this speed of road. The respects in which this is not a conforming lot are its area, which again, we are only proposing to use just a little over half of, and its frontage, which again is sufficient for us to propose two driveway entrances, both having more than adequate sight distance. So the respects in which this lot does not meet the present zoning are not being pushed by the abutter. Excuse me, by the applicant, I should say, sorry.
Okay, I'm gonna break in here. We got a problem. We're about to vote on whether we're even gonna hear you on this, on the merits of this, and you're going into a merit argument. I know there's a gray line here because one of the board members asked for some case law, but now we've crossed the line. So we can't be talking about this. So, and I want to add another thing. I think it's entirely inappropriate that this applicant has come before us while there's a Superior Court appeal pending. It's completely inappropriate procedurally. So, I mean, we can't impose sanctions, but I think it's inappropriate. And I probably have stronger words, but I'm going to keep them to myself.
May I ask a question, please, Mr. Chairman?
Yes?
Is it also town council's position that it's inappropriate?
I'm not going to hear from you anymore.
No, well, I mean,
It's none of your business what town council
well, that's because it's privileged.
advised us.
I mean, that's a privileged matter. We can't discuss what our attorneys have advised us, but yeah, we've consulted town council.
All right, and no
they
more
think-
talking out of turn, okay? You got anything more to say, you come through me. Paul?
I'd like to make a motion that we vote on whether we hear this, hold a hearing on this, its merits, or that we invoke the 4016, Chapter 40, Section 16 rule that this is not a valid application in the sense of it does not come within the 2-year timeline.
Do you want to have any discussion on that before you vote?
I don't think we need to.
Let's do a second, let's have a second.
I'll second.
Second. All right, do we need any further discussion on this?
I would like to discuss one thing. I think it's, I just think it's appropriate to make sure that the town council and the applicant has said everything that they do want to say regarding this article. And if they have any other comments, I think they should be heard, but other than that, just on the invoking this clause. I mean, I agree with you, we're not into the issues of the lot, frontage and these things, but I just want to make sure before we close this and when we vote on this, that they've said their piece regarding this, is it 40, whatever the law is, whatever.
4816.
48.
And
I just want to make sure they've said their piece on that.
All right,
That's all.
all right, we'll hear
And then we can vote.
from Attorney
That's my opinion.
Barre, not anybody else connected with the applicant on that narrow legal issue, 48, Section 16. Attorney Barre, would you like to be heard?
Thank you. No, I have nothing further to add. Thank you.
Okay.
Okay, so we have a motion, we have a second.
All right, so just to sharpen it up, and I appreciate that motion, so I just wrote this out. So we're going to vote basically to say that for the same thing
Tamika,
that Paul said.
excuse me, Rick, excuse
Yes.
me, Tamika has a,
Oh, Tamika?
If the board is going to make a vote, then we first have to vote to close the hearing, and that'll close all discussion for the board and the public.
All right, I think, all right.
But we're not actually holding the hearing. I
Well,
thought
we're still,
voting to
I
not
think
have-
Well, you
we're still
gotta-
discussing, I think we're still discussing it, but we will take a vote to close the discussion or,
Right, so any formal vote, though, about
Yeah.
the final decision will have to come after. the
right,
hearing.
we'll do that.
Okay.
We'll do that.
Rick, if I may just say one other thing, should we ask the applicant right here, because you're the guy that signed the form, correct? Do you want to just ask him if he has anything else to say on this? I know his attorney spoke, but he is the guy with his signature on the paper. I think he should just say, yes, I got something, or no, I got
If
nothing.
you want to be heard on the section 16 issue,
So I don't, no, I guess not on the section 16 issue.
Okay. All right,
Okay.
I'm good. I just want to make sure they had their chance to say
All right.
something about it. You know, I mean, we are,
Thank
you know, that's all.
Discussion then.
That's all.
Okay. So do you want me to make a motion to close discussion?
is there any, are we all done with discussion?
I'm
I'll
good.
second- I'll
Okay.
second it.
Okay, I'm good with it.
I'll just say that, from what I've heard from applicant's counsel, I haven't heard anything that would support the argument that 16A doesn't apply in these circumstances. I was waiting to hear something that really went to that point. I don't think I did, so that's where I come out on it as far as any further discussion myself.
So I'll make another motion to close discussion.
Second.
Okay, so
Any other
we're going to vote to apply 40A, section 16, and refuse to hold a hearing.
Vote to
No,
close
this
the-
is just.
Oh, we're voting.
Just to
Okay.
close discussion.
close
Yeah.
discussion.
Yeah, all right, all in favor?
All right.
Aye.
All right.
All opposed? Okay. So that carries. All right, Tamika, solid?
We're good.
Okay.
Thanks, Tamika.
All right, so now,
Do you need me to, is there anything that I need to sign or do? You guys are, everything?
Well, we're going to
We're
vote,
good.
so.
Oh, sorry.
we're
Do
good.
okay.
So we have the motion, and it's been seconded to,
Yeah.
Should we ask them to withdraw?
That's not for us to do.
No.
All right, no,
I don't.
just, I know sometime.
Yeah, no, I,
Okay.
yeah. All right, so what we're going to vote on, apply Chapter 40A, Section 16, and refuse to hold a hearing on the new application. All right, so all in favor?
all right.
All right.
Aye.
Right. All opposed? Okay, so we'll get the decision in 14 days.
Yeah, sounds good. Thank you.
Thank you.
Take it easy.
Good evening, thank you very much.
Thank you.
Thank you.
Attorney Barre.
Okay. Next item, the minutes for January 12th. I don't have any comments on those.
Look good to me.
All right, motion?
Motion to accept the minutes as written.
I'll second.
All in favor?
Aye.
All opposed? Any new business, Tamika?
I think we may have a variance coming down the line soon.
Okay.
I don't have the information from the applicant yet, but it's out there.
Okay,
Thank you.
thank you.
Good evening.
We have any other business?
Nope.
Nothing? Okay. Motion?
Motion to close.
Second?
Second.
All in favor?
Aye.
All opposed? Okay, thank you.